My name is Missy DeArk, and I'm with Dean Dorton, Allen Ford in Louisville, Kentucky. I'm a CPA and certified in financial forensics by the AICPA. I'm also president of the Kentucky Collaborative Family Network. I want to spend a few minutes today talking to you about the role of the financial neutral in collaborative practice of family law. So what is collaborative practice? Collaborative practice is a dispute resolution process. Basically, it's settlement by agreement. It replaces the adversarial techniques in litigation, such as filing of motions, interrogatories, depositions, and could be eventual trial. Active participation by the parties in negotiations is crucial. Clients, being the spouses, and team members agree not to litigate. So who is the team? There are three components to the collaborative practice team. The first are the lawyers. Each spouse is represented by a lawyer. Also, there is a relational neutral, more commonly known as the mental health coach. And then finally is the financial neutral. So what role does the financial neutral play? Financial neutral helps parties identify, clarify, and prioritize their financial needs and their goals and concerns. And typically, in divorce situations, this means education of more of one party than the other. Typically, we'll see that one spouse dominates in the financial aspects of the marriage. So it's very, very important that as a financial neutral, we gain the trust of the party that is not used to dealing in financial processes. We need to validate their emotions when they arise. So make sure we listen clearly, and answer their questions. Help the parties to make informed decisions on a level playing field, so they feel like that while they may not have been dominant in the financials of the marriage, they can make decisions and feel empowered. Communication is critical. Communication with the team as well as the clients on all the financial matters involved in the case. We really bring the voice of financial reality to discussions, and sometimes that can be very difficult. There's, of course, situations where the parties their liabilities may exceed their assets, and how do we handle those types of conversations can be extremely difficult and important. At the end of the day, we're trying to help the clients, the spouses, reach durable agreements and keep them out of litigation. So what are some of the things that we do in gathering financial information? We have an open exchange of information. So there's not interrogatories. However, depending on what type of work the financial neutral is performing, we'd request things such as pay stubs, tax returns, bank statements, credit card statements, retirement account statements, could be an IRA, Roth, 401k. You want to inquire about insurance policies that the parties may have. Usually the largest asset in a marriage is the house. And so mortgage information, appraisal information regarding the parties' real estate is also extremely important. What are some of the financial services that we as financial neutrals can provide in this type of negotiation? First of all, if the parties do have a business valuation would be extremely important. And in order to do that, again, there's the free flowing of information, and so we would request the appropriate information and share that with both parties as we come up with our calculations in valuing those businesses. Secondly, could have premarital or non-marital tracing issues. If the parties are in a second marriage or third or later, this tends to become a big issue. Third, we help the parties calculate their income, and this is very important for purposes of child support, alimony. Probably one of the most popular services that we help with is the advice on tax planning. This could be, how the retirement plans are divided. What are the potential capital gain issues for assets held by the party? Again, alimony calculations, and what does that mean, and how does that affect their tax situation? Also, at the end of the day, again, we're helping them prepare and assist to get a resolution and try to get an equalization of the assets of the marriage. Finally, what we must remember when we're working in this type of environment, we're working with attorneys, it's not much different than when we're working in other litigation scenarios, and that is, we are an advocate for our calculations, for our work product, unlike attorneys and lawyers who are an advocate for their client. We, again, are an advocate for the work that we produce, whether it be calculations or opinions or any type of work the accounting may require. Secondly, we do not provide legal advice. Again, leave that to the lawyers. It's their job to provide legal advice. And finally, we do assist in helping with a final settlement. However, we do not control the final settlement. Again, we're not lawyers, and we don't draft agreements. We assist in helping get a final settlement. At the end of the day, I very much enjoy working in the collaborative process. Typically will result in a much better outcome for the parties when they can sit and work out their differences together. Doesn't mean it's not going to be difficult. However, to be able to stay out of court and try to resolve among the parties seems to be the best solution.